The following is a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys. The Siniard Law Show, answering your legal questions, featuring attorneys Tommy Siniard, Bart Siniard, and your host, Aaron Dacey. This is the Siniard Law Show.
Hello and welcome to the Siniard Law Show, where we invite your legal questions and educate you on various areas of the law. Siniard Law is a father-son personal injury firm right here in the Tennessee Valley, focused on giving back to the community through legal education. Siniard Law has again received recognition as the Tier 1 personal injury litigation firm by Best Lawyers in America. Tonight, we're discussing personal injury law. Bart Siniard is joined by another attorney in their firm, Heyward. Good evening, gentlemen. Thank you so much for being here.
Glad to be here, Aaron, as usual.
Good evening, Aaron.
Yeah, we're going to have lots of good questions. So if you have questions on this topic or any other legal topic, just email us questions@siniardlaw.com or call us at 844-7000-LAW, and your question may be featured. Now to our legal tip of the week. What is contributory negligence? It is different in different states, and so right here we're between Tennessee and Alabama.
So Alabama has what it is now unique in regards to how fault is determined. In 46 states, they have what's called comparative fault, which means if you contribute to your own injury, you can still recover money. For example, if you were speeding at the time and somebody ran a red light and hit you, that would not be a problem for you to recover money in most states, in 46 states. Wouldn't be a problem in Tennessee, Georgia, Mississippi, Florida. But it would be a problem potentially in Alabama because we have what's called contributory negligence. In Alabama, if a judge or jury thinks you're 10% at fault for an accident, you get zero. In Tennessee, if a judge or jury thinks you're 10% at fault, you get 90% of your damages. So I always tell people who've been in some type of accident, particularly in Alabama, you have to be wary of that when you're talking with somebody at an insurance company, because they know about the contributory negligence doctrine, and they are hoping to find some information, particularly from you, the injured person, that you may have done something that contributed to, the car accident or the trip and fall at the grocery store, whatever it may be. And I mean, you see that, we see that every day.
We see that every day, and then when we go try cases, it's if the defense is able to argue it at trial, a ton of emphasis gets placed on that. Now they have to prove that our client contributed in some way, but I've heard defense attorneys get in front of juries and just say 1%. If you determine that Mr. Heyward's client contributed just 1%, which, by the way, that's not written in the law anywhere, but we hear that argument a lot, and in some cases it's persuasive. In cases like Bart said in other states, that would never be an issue. Yeah,
I mean, as an example, I had this is a real case, I won't say names, but I had a client whose dog escaped. He was in a residential neighborhood, and he went out into the street to get his dog. There's a car coming, several houses down, and he assumes this car sees him, and he waves at the car, but he's trying to get his dog's collar. For whatever reason, the car driver doesn't see him and hits him, flips him up into the air, and he had bad injuries. Well, the insurance company denied that claim because my client was in the road, not in a crosswalk. And ultimately, the jury sided with them because of the contributory negligence doctrine. The jury didn't really, I don't think, want to, but when the judge tells the jury, this is the law, if you find the injured person contributed to it, then they're not supposed to win at all. So it's something, particularly if you're in an accident in Alabama, you got to be aware of and be careful what you say to people about it. Even a Facebook post that has pictures and you describing the accident, that might be used against you. So you got got to be wary of that in Alabama.
And like you said, the insurance companies be very
They know about it, and they're trying to just get one tidbit of information they can and say claim denied.
Yeah, like you said, the 1%.
That's right.
Yeah.
Let's get to our viewer questions. Our first question tonight is an email from Luke. He says, my son was a passenger in a pickup truck on private property. The driver was only going a short distance, and at first he was driving slowly. When they came to a turn, he tried to show off in the mud and hit the gas. The back end spun out and ejected my son and another boy out of the truck. My son was badly hurt. I'm concerned that the insurance company is going to deny my son's claim against the driver because he was sitting in the bed of the truck.
Yeah, I've had a case similar to that a few years ago. You want to take this one?
Yeah, well, this is a perfect lead-in from contributory negligence, because I can tell that that's probably what Luke is concerned about here. Either that his son, they'll decide, contributed, or that there's something against the law that says that you can't sit in the bed of a truck, which, to my surprise, in Alabama, there actually is no law against sitting in the bed of the truck. And so they would have to prove that Luke's son did something by sitting in the bed of the truck that contributed to cause this accident. I think that would be a tough argument. I mean, this sounds horrible, and I can understand young kids just wanting to show off for their friends. I really hope that he's okay, but I think Luke should rest assured that there is no law that says that your son couldn't have been there. And then certainly I would add on top of that, on private property too.
Yeah, that matters. And another thing that may matter is what age his son is, because there is a law in Alabama that if you're 15 or under, you have to be buckled up. And obviously you can't be buckled up if you're in the bed of a truck. I would argue he didn't know this was going to be dangerous. It was so unlikely. They're on private property, weren't planning on racing or anything like that.
Sound like a spur of the moment decision.
Yeah, this is a winnable, in my opinion, winnable case that you could probably get resolved with the insurance company that's applicable. But you got to be careful. If you say, oh, they were going out joyriding and racing and flying around, that's going to create problems in the claim, because that's going to bring up the contributory negligence or assumption of the risk defense.
Yeah, and one thing that I would add to it also is that I think there's a really strong argument that the driver of the truck knew at the time that he did this that it was dangerous. And that would bring up a wantonness claim, which just means that he knew the risk and he did it anyway. It's not simple negligence. Contributory negligence it's not a defense on a wantonness claim, and that's another angle as attorneys that we would look at.
I forgot that his question said the driver was charged with reckless endangerment. So that really changes things. That makes your odds of winning the claim much higher, because like Barnes was saying, these defenses we were talking about are not applicable if the at-fault driver was being reckless. That's another word for wanton. Wanton's the legal word, but if they're being wanton or reckless, which means acting extremely dangerous, like drunk driving, street racing, then those defenses go away, because the law in Alabama and in most states is when you're being extremely dangerous, those defenses go out the door, because we want to punish that kind of behavior.
Because you should know better.
Yeah.
Absolutely.
Got it. Now let's listen to a voicemail from Rita.
Hello, I suffered a work-related injury that resulted in an ACL and meniscus tear. My medical treatment was covered by my employer, but I was offered a settlement that I didn't think was sufficient and declined. I'm hoping to speak with someone about my situation. Should I have an attorney review it?
I get this call a lot, at least once a week, and assuming this happened in Alabama, we have the Alabama Workers' Compensation Act that applies to any on-the-job injury. And there's three main benefits she's entitled to. Number one, which it sounds like they've been doing, is paying for 100% of medical treatment. You're not supposed to have any out-of-pocket costs. You're not supposed to have any copays, even medications, 100% supposed to be covered. Sometimes there's some issues with that. They'll give you pushback, but that's the law. The downside of that is they get to pick your doctors. They're approved by the workers' comp insurance company. So workers' comp insurance kind of has this right to kind of control your medical treatment. Not control your medical treatment, but control which doctors you see. And a doctor has to say, oh, she needs physical therapy before workers' comp will pay for it. So that's the first benefit, medical. The second is while you're out of work, but only on doctor's orders, they have to pay you 2/3 of your average weekly wage. And that's calculated based on the average pay of the prior 52-week period. So some people aren't paid hourly, they're salary. But, you know, they have bonuses at year end, whatever. That's calculated. You're basically supposed to get 2/3 of your average pay while you're out of work, but only if the doctor says you can't work. So that's the second benefit. Third benefit is what Rita's calling about, and that's called permanent partial or permanent total disability benefits. If you have what's considered a permanent injury, and that can, even when it's not permanent as you would think of that word, it may be considered permanent under the workers' comp statutes. Like if you have to have, you know, a torn rotator cuff and have to have a surgery, that's considered a permanent injury. In her situation, she has a leg injury, a knee injury. Alabama is really rough for people who have workers' comp injuries to what's called scheduled body parts. There is literally a list in the statute of what body parts are worth. Fingers, hands, arms, legs, feet, toes, even eyes. Like one eye is worth a set amount. And it doesn't have a dollar amount in the statute, but it has a weeks amount. Like a leg is 200 weeks. And how it works is you basically calculate the weeks times your average weekly wage times whatever your impairment rating percentage is. Mm-hmm. And it spits out a number. And, you know, a judge doesn't have to agree with what your impairment is, but a lot of judges will just say, okay, the doctor thinks you have a 10% impairment to your leg, so they apply the formula and this is what you get. It's a pretty straightforward formula, at least when the injury is to one of those scheduled body parts, arms, legs. So I could, you know, if she tells me her average weekly wage and what her impairment rating is from the doctor, and she may not know that, but it's in her medical records, I could run the math in less than 30 seconds and say, this is what you're entitled to. Now, to the viewers, if your injury's to a body part that's not on the schedule, it's different. If you have an injury to your neck or a brain injury or to your back or even your shoulder or your hip, total blindness, total deafness, those are injuries that are not on the schedule. And there's a completely different formula, which in most cases is much better for you. You have a much better chance of getting more money. But you know, like you lose an arm in Alabama and you make close to minimum wage. I mean, there's articles about this. You may only get about 46 grand for like literally losing your arm if you're a lower wage earner.
Yeah, and that's most people's response is wow.
Alabama has not changed its workers' comp statutes since, I believe it was the Nixon administration. I mean, like 50 years ago. Yeah. They haven't updated the formulas or the rates or anything. You know, and $1 used to get you something, and now it doesn't get you anything. And it's not adjusted for inflation or cost of living or any of that. And it's sad. Alabama has the worst laws for injured working people in the nation. And it's really bad when the injury is to one of these scheduled body parts.
Very interesting. Not good news for workers. When the Siniard Law Show returns, we'll get to more of your legal questions and we'll tell you how you can sign up for the Siniard Law Firm's free monthly newsletter.
Harrison Brothers brings together the best of North Alabama. Our curated selection of local art, fine crafts, and gourmet food are great gifts for everyone on your shopping list. We carry books by local authors, and our toys pique a child's imagination. At Harrison Brothers, your purchases support artists and artisans right here in the Tennessee Valley. Located on Huntsville's Courthouse Square since 1897, Harrison Brothers is more than a store. It's a tradition.
I got sandwiched between an 18-wheeler and a truck. During the accident, I lost my left leg. I chose Siniard Law because my granddad knew they had a great reputation. They were very knowledgeable. They were very sweet. We had a connection. They pretty much treated us like family. I would definitely recommend Siniard Law because they are caring and they will help you get what you deserve. If you've been injured, call Siniard Law.
Welcome back to the Siniard Law Show. If you would like to sign up for Siniard Law's newsletter, which provides free monthly legal tips, scan the QR code or be sure to sign up at siniardlaw.com. Now let's get back to you, our viewers, and your questions. We have an email from Jeff. Jeff says, I own a boat that I dry dock with a marina at Smith Lake. I recently got it out of storage to take some friends out on the water. When storm clouds rolled in, I drove the boat back to the marina and 2 dock hands came to assist me in getting the boat back out of the water. I suppose they were in a hurry with the weather coming in, and the forklift operator began to lift the boat out of the water while I was still standing on the transom, causing me to fall several feet on the dock, badly injuring my knee. What kind of claim do I have?
That's a wild situation.
It's a simple negligence claim. I wasn't sure as you were reading it, where this was going to fall, but this looks like a simple negligence claim against the marina, against the dockhand, especially the one who was operating the forklift. And I would assume that they have a reasonable duty to make sure that no one is on the boat at the time that they take it out of the water. Now, what's interesting is what the dockhand says, because again, to me, that's a contributory negligence argument. They're going to make the argument that everyone was off the boat, they had the all clear, and then he jumped back on the boat. And it's fortunate that his wife and his friends saw the whole thing. I think that witness testimony will help take care of that. But you can already see them previewing the argument that they're going to make. And, it's going to come down to, again, what is reasonable. And maybe there are policies within the marina for forklift drivers about how exactly they're supposed to take boats out of the water, what precautions they're supposed to take, what things they're supposed to kind of check off of their mental checklist before the boat comes out of the water. Certainly, we can assume that it would be unsafe for them to take a boat out of the water while someone is still standing on it. So, from his standpoint, I think it's a simple negligence claim. From the marina's standpoint, clearly they're going to argue that he did something to add to this situation.
It's one of those cases where I'd want to send an investigator out to the marina really quickly, and there probably isn't, but there might be surveillance camera in the area. So instead of having this he said, she said war between witnesses, you can see if there's actual truly objective evidence as to what occurred. And there probably isn't. I don't think I've been on many marina docks that have video cameras out there, but it could be a possibility. I'd want to line up all the witnesses you could, because it may be a battle of he said, she said. And, like we talked about at the beginning of the show, the contributory negligence doctrine, if they can convince a judge, a jury, or whoever they need to, that you contributed to your injuries, then you lose. Of course, they have an incentive to maybe fib, but they'll argue you have an incentive to fib because you're making a claim and trying to get money. So, I would line up all the witnesses you could. Obviously your wife and your friend that were there, but if there's anybody else, like particularly a complete stranger who has no incentive to make up something, those what we call independent witnesses are super credible because they have no dog in the hunt. They don't have any motivation other than to tell the truth. So, if it becomes an issue and they're still fighting you and not going to pay you anything, having that independent witness, that you really just can hit them over the head with that.
Yeah, Bart's right. We prefer not to be in the middle of he said, she said cases. And so we're always going to be looking for some other evidence. Maybe it's an independent witness. Maybe it's surveillance footage, something that we can hang our hat on to say, hey, look, he may say this, they may say that. This tips the scales in our favor.
Yeah, because if you're the one making the claim, you have the burden of proof. And it's not like a criminal case where you have to prove your case beyond a reasonable doubt, but you still have the burden of proof to reasonably satisfy the judge or jury that what you're saying is true. And we basically break that down as 51%. You know, are the scales adjusted, tilted just enough to where you think we're probably right? And he said, she said cases really come down to the credibility of the witnesses. You know, if the dockhand's a super credible guy, impeccable character, likable, you know, you may have a problem on your hands. You know, so a lot of it comes down to how presentable and credible are the witnesses. But still try to find that independent evidence, whether it's video or witness statements or anything else that can kind of corroborate your version of events. Try to think outside the box.
And get that video quick, right? Because it can disappear.
Yeah.
Be recorded
Yeah,
over or
it
whatever
does.
if there is a chance.
Yep,
there
that's
is
true.
some. Thank you very much. Now let's hear a voicemail from Jessica.
Hi. Recently, a truck hit me from behind while I was sitting at a stoplight. The guy didn't have any insurance. I do have full coverage, but my car ended up being totaled. I'm just trying to figure out if there's any chance the driver can pay for the damages.
Full coverage. We hear that a lot. It may not mean what you think it means. We hear full coverage and people assume that must mean that I've got coverage. If this guy doesn't, what she's referring to is underinsured, or in this case, uninsured motorist coverage. But you need to go check and make sure that that's the case. Because sometimes people think they've got it, and then we find out later on that they don't.
Full coverage is not actually a thing.
Yeah.
That's something
Sounds good though.
It's something
doesn't it,
that
for a marketing thing?
it does. It's something that the insurance agents, and I love insurance agents. I love my insurance agent. Not talking bad about you all guys, but a lot of agents use full coverage to make it sound like you're fully covered for anything that could happen in this world, and your policy actually doesn't. Car insurance has a lot of different buckets. And I mean, there's 5 main parts of true full coverage. To be truly covered for everything, it's liability coverage. That's something you have to have required by law. Minimum limits are $25,000. The next bucket, and none of these other buckets are legally required, but if you can afford them, you need them all. Second bucket is collision coverage. That covers damage to your car, whether it's totaled or repairable, regardless of who is at fault in a car accident. So hopefully she has that because the person who hit her doesn't have car insurance. The third bucket's comprehensive. That's if a tree limb falls on your car, or somebody vandalizes your car, somebody steals your car. Collision coverage doesn't cover that. Comprehensive does. That's going to cost you a little bit extra. And then you have what Barnes just talked about. The fourth bucket is uninsured/underinsured motorist coverage. That is for injuries, medical costs, pain, suffering, mental anguish, loss of income. If you are hit by somebody who has no car insurance, like this person, or doesn't have enough car insurance. And then the fifth bucket is medical payments coverage. That will pay out-of-pocket medical costs for anybody in your vehicle who is hurt, regardless of who is at fault. You can get as little as 500 of that. You can get 100,000 of that. So that's the 5 main buckets. And then there's other things like rental car reimbursement, towing things. There's a few other add-ons, but those are the 5 things. And unless you have all 5 of those things, in my opinion, you don't have full coverage because there's things you're not covered for. If you don't have comprehensive and that tree limb falls on your car while it's in the driveway after a bad storm, it's not covered unless you have comprehensive. You could think you have full coverage because you have collision and liability, but in my opinion, you're not fully covered. Now with Jessica, if she called our office, what would you tell her to do in this situation? She's hit by an uninsured motorist. She has damage to her vehicle. Seems like she's got medical bills. I mean, what would you tell her?
Well, the first question that I have is about what does she mean by full coverage? Does she have a copy of her, what's called her declarations page? You might hear it referred to as a deck page. But I usually tell people, hey, you need to go and ask your own carrier for your deck page to find out exactly what coverages you have, and then we can kind of proceed from there. But it's amazing to me how few people know what coverage they have under their policy.
Yeah. And, you know, if she has collision coverage and she has uninsured motorist coverage, should be in good shape.
Yeah.
If she doesn't have collision, she's not going to be in good shape with the car situation. If it's total loss and the at-fault driver doesn't have car insurance, that usually means they don't have much money to go after.
Yeah.
You can go bankrupt them, but it's not going to help you. That's why if you can afford it, you really need collision coverage.
You guys have talked about how few people have insurance. How many people are driving around on the road? Didn't y'all say that it was like
19.5% of cars on the roadway, at least in the state of Alabama, don't have car insurance on them. What people do, and I get it, you know, people struggle financially, and that's one of the things that they just sacrifice because they need to focus on paying the utility bill, paying the grocery bill, paying rent. So I get it. I'm not faulting those people at all. I know that's an easy cost to cut, and hopefully you don't get in a wreck and you're just trying to get to work.
Yeah.
You know, I get it. But for those people who are hit by an uninsured motorist, if you can afford to, you got to protect yourself by having collision coverage and having uninsured motorist coverage. Just get the bare minimum, because almost 1 out of 5 cars out there on the roads in Alabama don't have car insurance. So, you know, I think the studies are you will get in 3.2 wrecks in your lifetime. And if 20% of those people out there don't have car insurance, you got a decent chance in life of getting hit by somebody who doesn't have car insurance. If you don't have collision, you're out of luck with the car. And if you don't have uninsured motorist coverage and you're injured, you're out of luck.
I think it's worth talking about gap coverage too, because we see this a lot. And, you know, we would certainly encourage you, if you're going to buy a car, and this isn't possible for everyone, to be able to put down a large enough down payment that you're not going to get upside down on the loan. But, you know, for most people, that's simply not realistic. And we run into that circumstance where maybe there is collision coverage, but the insurance company is only going to pay the fair value of the car. And so the second you drive it off the lot, it's going to depreciate. You may still owe more on the car than what it's worth. I'm really thankful when people have gap coverage when they're in that situation, because whatever collision may pay or the liability carrier may pay for the value of your car, let's say if it's totaled, then gap coverage will pay off the remaining balance of the loan.
Yeah.
It's really sad when I've got clients who have to replace their vehicle, and now they're paying 2 car payments, one on the new car and one on the remaining balance from the first car.
That's so informative. Thank you both very much. We appreciate Bart Siniard and Barnes Heyward from Siniard Law for all of this information about liability, and we look forward to hearing from you, our viewers, with questions about any legal topic. You can email us at questions@siniardlaw.com, or you can call our voicemail line at 844-7000-LAW. Join us next Sunday night after the late news. Good night.
The preceding was a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys.